Yes, sir. Yes, we can start. Good evening to one and all. I sincerely welcome all the seniors, friends, and the participants on behalf of Team Legal Speak webinars. I welcome Sri Ethirajulu sir, who is going to give presentation on the topic of embodiment of judicial activism, decorum, and discipline in judiciary. Sir, there is no need to introduce Mr. Ethirajulu sir. He is familiar to all. He can start his speech. He is very well known to all. That is why he can start his speech and he can give his representation. I sincerely welcome all the participants and the presenter. Thank you. Thank you for all.
I am Ethirajulu, Advocate, Madras High Court. I welcome all the senior, junior, and friend advocates into this webinar. Before, as well as various other high courts in other states in India. At this stage, I want to point out that I have also read some of the topics in journals written by eminent jurists. So I have culled out certain points from the journals also. After going through all these things, I am of the stubborn opinion, judicious is a beautiful word, which means good judgment with common sense. This is called active judicium. The shapers of good judgment are known as judicial officer, who has to play a multifaceted role in a society, especially in judicial and administration side. Their duty is to interpret law by assessing evidence and documents presented before them, and they have to decide on what way they have to conduct a hearing and conduct the trial. Thus, their duties and responsibilities are onerous. At this stage, I want to say that a case, if you take it for trial, there will be two persons, namely plaintiff and defendant. One may have sword in his hand, another may have some shield in his hand. Whatever things they fight before the honorable court, the judge, namely the judicial officer, has only have the sword in the way of law. These laws are not permanent one. It will may change from day to day. So they have to improve themselves before taking over a case and completed it same in its tenure. So that's why we say that the role played by the judicial officer are very responsible role in the judiciary, because it is the lay foundation of the four-floor building. Four-floor building means this basement is the original site, and first floor is the second floor, and for the second appeal is the third floor, and fourth floor is High Court, and fifth floor is Supreme Court. So whatever judgment this judicial officers is writing, it should withstand all these floors to its end. Therefore, they are very, very careful while writing a judgment and collecting the facts from the case and fitting to the law. These are the studious job entrusted to the judicial officers. So therefore, in that capacity, the adversarial system of justice, they must ensure the evidence of both sides and allow them to fully present their case and hear the case to their utmost satisfaction. Then only a judicial officer are capable to provide an independent and impartial assessment of fact and apply the law to fit into those facts. In the said process, judicial officers have to maintain cordial relationship with bar by fulfilling their just demand, but at the same time, they should not succumb to pressure since judicial officer has got against nepotism and favoritism. The foremost qualification of the judicial officer is to stay calm and not get angry, especially when there is some difficulties or waiting for a long time to complete the trial. The judicial officer is to be dignified, respectful, and courteous towards advocates, litigants, witnesses, and others who come across in their official work. The over pressure given to a proceeding officer, in some time, it may result in some shabby judgment because of advocates and claims. Certain incorrect statements and incorrect evidence leads to this kind of judgment. Then we used to try by selling a maxim that hurried justice is buried justice and delayed justice is denied justice. This is the Taraga Mandram of most of our advocates as well as the litigants. In order to avoid this kind of practice, we have to be very careful in drafting as well as in presenting our case before the honorable judges to come to a correct conclusion. So therefore, these are certain things for the it comes under the judicial activism. It is the root cause for implementing the judicial activism in the judiciary. Now let me speak about judicial activism and its scope. The judicial activism originally appeared to be coined by an American scholar in judiciary. And what is the meaning of judicial activism? It is only the willingness of a judge to strike down the action of another branch of government or overturn a judicial precedent with no implied judgment as to whether activism decision is correct or not. An activist judge enforce their own views of constitutional requirement rather than deferring to their views of other government authorities or verdicts of earlier courts. To describe judges as activists in the sense is to argue that they decide cases on basis of their own policy preference rather than a faithful interpretation of law, and thus abandoning the impartial judicial role and legislating from the bench. The judicial activism is a ruling issued by a judge by overlooking legal precedents and past constitutional interpretation in favor of protecting individual right or serving a broader political agenda. Therefore, the judicial overreach is an aggravated version of judicial activism. Judicial activism seen as success in liberalizing access to justice and giving relief to disadvantaged ground because of the efforts made by Justice V.R. Krishna Iyer and Justice P.N. Bhagavati, then judges of Honorable Supreme Court. There are various methods of implementing judicial activism through judicial review, public interest litigation, constitutional interpretation, access to international statute for enforcing constitutional rights, and supervisory power of High Court under Article 227 of the Constitution of India. These are the 5 things in support of this judicial activism. All judicial activities some has taken place only in view of this file proviso to our judiciary. Now we'll consider what is the significance of activism, judicial activism. It is an effective tool for upholding citizen rights and implementing constitutional principle when the executive and legislature fail to do so. Citizens have to judiciary as the last hope for protecting their rights when all other doors are closed and all avenues as well as. Then only this judicial activism is sprouted from our courts. The judicial first thing I want to tell that this judicial activism was effectively handled by Allahabad High Court while rejecting the candidature of erstwhile Prime Minister of India, Srimati Indira Gandhi, during the year 1973. And there, before that, in Golaknath case relating to the question whether the amendment is a law and fundamental rights can be amended or not, the Supreme Court answered that fundamental rights are not amenable to the parliamentary as stated in Article 13 of the Constitution of India. In Kesavananda Bharati case, it also held that basic structure of constitution could not be abrogated even by a constitutional amendment. These are the three cases where this judicial activism are founded by our courts. Apart from all these cases, so many other cases, Honorable Supreme Court of India and Honorable High Courts effectively handled judicial activism in the case of Aadhaar card, whether it is effective validity of the Aadhaar card, and 2G and 3G spectrum cases, and challenging the exemption granted under Section 18(1)(j) of the Right to Information Act. These are the three cases were handled by the Supreme Court, and in the High Court, wearing of helmet compulsorily and removing of wine shops on the national and the state highways and compensation cases are made only out of using this caption judicial activism. But unfortunately, at the first instant, Supreme Court is agreed and also confirmed the judgment of the Honorable High Court Madras in the case of removing the wine shops from liquor shops from highways, both national and state highways. But unfortunately, thereafter, several modification petitions were being filed and entire judgment, original judgment was watered down. This is the only occasion the judicial activism failed in our country. The Honorable Supreme Court of India, in a case reported in 2008, 11 SCC 413, laid down a principle to the effect that courts should be slow to interfere with the mandate of legislature except for compelling reasons. These are the principles laid down during the year 2008, wherein this case was emanated from Punjab. What happened in this case? In a Punjab, a person is worked in a department that is quasi-judicial department as a fireman, that is market committee. He worked as a fireman. He stood for the election conducted to the Gram Panchayat. And he is also a successful candidate who won the election. The defeated candidate filed an application before the tribunal and challenged the election itself, where he says that at the time of notification of election and declaration of election result, the elected candidate is worked for profit in a quasi-governmental organization, and that And he has also said that the Panchayat Raj Act in Punjab, as well as Punjab State Election Commission Act, prohibits such a person standing for an election. Agreeing with this case, the election petition was allowed and the second vote, the highest voter was declared elected. Agreed by the same, the elected candidate filed an appeal before the Honorable High Court of Punjab and Haryana before a single bench. What happened? The single judge felt that there is some inconsistency with these two acts and referred the matter to a division bench. The division bench was taken out this case and also compared these two judgments and found out that there is a saving clause and repealing clause in the subsequent act. Then they come to a conclusion that already elections were made and results were published. Only after that, the state government has passed that order. So there is no bar for standing the election. There, only because of this judicial thing, they found that the Supreme Court, when High Court has confirmed the order passed by the tribunal, by the bench, and it was taken to Supreme Court. Supreme Court only has ascertained all these things by using this method of judicial activism. Only because of that, we are saying that judicial activism plays a bigger role rather than the mere law exists in this country. Because the law may change one day, because they are often changing the law, because Hindu Succession Act went and property, Transfer of Property Act undergone many changes, but even our constitution has not, basic structure has not been changed, but certain provisions are included in the Constitution of India. Structure-wise, therefore, a judgment should be correct, up to date. They have to be up to date on the date of hearing the case. Only on the basis they can go into the facts and fit in law with that fact. Only because of that, I have stated that case. Because of all efforts, they have made it to a success. Then, an active judiciary is one that takes its task of defending the fundamental rights of people and their liberties against the onslaught by state earnestly. One judge may say policy formation is the job of executive, while other judge may say even in policy formation, judiciary would need to step into guard fundamental rights. There are different kinds of judgments are there, still it persists. Therefore, a judicial activism has played certain role there, and to decide that if it is not fit into the fundamental right, it can be easily thrown out. This is several judgment now as given by that. But the question will remain, when legislature violates any fundamental rights or constitutional values, who is to be the arbiter for that? In that event, judiciary has to be acted as an impartial umpire, and that is the task entrusted to the judiciary to ensure that fundamental rights are not breached and basic constitution value are preserved. Even new decision on every new situation is a development of law, as per the words of Justice V.R. Krishnaiyer. Law does not stand still, it moves continually. Once this is recognized, then the task of judges is put them on a higher plane. This is called judicial activism. A healthy growth of law, last but least, will make judicial activism when it is within the boundaries of guidelines prescribed for the same. Now, recently we come across Sathangulam case. That is a recent trend where the Honorable High Court of Madras bench itself has taken cognizance of this offense and they converted a writ petition and they themselves suo moto initiating action. This is a typical example for using the judicial activism in the field of judiciary. Now, only after this writ petition, all these things are happening and law was set in motion. So whenever legislature failed to do that, the judiciary to take their own course to put the law on motion. This is a classic explanation now we have seen in our Tamil Nadu. This is regarding the judicial activism. With regard to judicial decorum, I want to make certain submissions. A judge, with regard to judicial decorum, I want to say that a judge is not to be guided by any kind of notion. The decision-making process expects a judge to apply restraint, austerities reciprocal subjectivity, make one's emotion subservient to one's reasoning and think dispassionately. He is expected to be guided by the established norms of judicial process and decorum. A judgment may have rhetorics, but the said rhetoric has to be dressed with necessary and reasons and must be in accordance with legal principle. Sometimes this kind of judgment likely cause prejudice to a person, especially when that person is not a party. Therefore, courts are not expected to give any kind of prejudicial remarks. In that context, rhetoric becomes sans reason and without root. Therefore, a judge is required to remember that humility and respect for temperance and chastity of thoughts are at the bedrock of opposite expressions. Thus, a judge should be abandon his passion. He must constantly remind himself that he has a singular master, which is called duty to truth. And such truth is to be arrived at within the legal parameter. No heroism, no rhetoric in these cases. Caustic observation not necessary as an integral part of an adjudication, which affects person's right under Article 21 of the Constitution of India. These are the maxims which are culled out from various judgments. If anybody wants, I will give that judgment also for their ready reference. Then, we have a famous case. Then, Supreme Court has also said that in one of the cases in Gujarat High Court judge has, while hearing a petition filed for condemnation of delay in a second appeal, on the ground that there are shortage of staffs both in government pleader's office as well as public prosecutor's office. What happened while ordering notice to the concerned parties? The Honorable Judge has passed another order directing the Chief Secretary of Gujarat to appear before him on a particular date. And the Chief Secretary also appeared before him, but he was not treated as dignified manner, because when the matter goes to Supreme Court itself says Supreme Court is not satisfied with this action, and he was asked to stand for whole time, and a scene was created there by other advocates sitting there, and so many promotions are went in. Then finally, the case was filed. Case was filed before the Honorable Supreme Court of India. The Supreme Court in its judgment, it says that there is no doubt that High Court has enormous power to summon officials, but Honorable Supreme Court opined that he should not have called upon frequently, and it should be done in very rare and exceptional case when there was compelling circumstances. The Supreme Court expressed dissatisfaction against the judge and also directing him to resolve the issue by deliberation with officials and government leader and public prosecutor. This is also a reported case. That's why I have annexed the things with my speech today. Said that senior officials should be given proper respect by the court, and they should. Varda sir?
Varda sir, clearer sir, impressive sir, continue.
And the senior official need not be made to stand all times when the hearing is going on, and they can be offered a chair by court to sit. They need to stand only when answering or making a statement in the court. The senior officials do have their self-respect, and if the court gives them respect, they in turn will respect the court. And they also made a maxim that respect begets respect in this case. Another case which was reported in journal 2013 3SCC, page number 1. This case arises from Gujarat. In Gujarat, there is a dispute with regard to fulfilling the formation of Lok Ayukta during the year 2003, and the case went up to Supreme Court. What Supreme Court said that we are not going to interfere anything with this case, and also they want to lay down certain materials for the country, where this judgment was delivered by Justice Dr. B.S. Chauhan and Justice F.M. Ibrahim Khalifullah. In paragraph 1 or 2 of the judgment, it is stated that judges must act independently and boldly while deciding a case, but should not make atrocious remarks against a party or a witness or even against subordinate courts. Judges must not use strong language, harass and disparaging strictures against any person who may be mistaken or unjustified, and in such an eventuality, they do more harm and mischief than good, therefore resulting in injustice. Thus, the court should not make any such derogatory remarks unless the same are necessary for the purpose of deciding the issue involved in a given case. Even where criticism is justified, the court must not lose temperament and intemperate languages, and must maintain judicial decorum at all times, keeping in view always the fact that the person making such comments is also fallible. And concludes, learned judge says that even if he did not approve of the my way or the highways attitude adopted by the Honorable Chief Minister, ought to have maintained a calm disposition and should not have used such harsh language against a constitutional authority, that is the Chief Minister. This is a judgment rendered by the Apex Court with regarding to judicial decorum. So judicial decorum is not a building which is decorated. Judicial decorum is the subject which has to be decorated, and it teaches how clients and judicial officers has to work in this room to maintain the dignity of the court. These are the things speaks about the judicial decorum of the court. Now I'll take another topic, that is judicial discipline. The judicial discipline means the personality and behavior of a judge should be judged. No one in and outside the court feels uncomfortable. The doctrine of judicial precedence, judicial discipline, contempt, and res judicata have been evolved to ensure stability and continuity in law and deterrent action in case of its violation by subordinate courts and tribunals. Otherwise, any judge could take any view on the interpretation of law, resulting in chaos. The Honorable Supreme Court of India, in the case of Union of India versus Kamachi Finance Corporation, reported in AR 1992, Supreme Court 711, held that judicial discipline requires that decision of higher authority should be followed in the case of quasi-judicial authority, and therefore a lower officer should bound to follow it. Sometimes an argument is made and also put on record that department has not accepted the decision of the tribunal and the appeal has been preferred to the High Court. However, courts have repeatedly held that phraseology of not accepted decision is obnoxious and unparliamentary in respect of the order of the higher authority. If the statute is an all India statute, decision of benches of the tribunal at various places are considered as binding on the law, point decided on the principle of judicial discipline. In the case reported in Ruplal versus LG of New Delhi, reported in 2000 Supreme Court cases 644, Honorable Supreme Court expressed its serious dissatisfaction the manner in which a coordinate bench of tribunal has overruled in effect an earlier judgment of the same tribunal and held it is opposed to principle of judicial discipline. This is a fundamental principle which every presiding officer of judicial forum ought to know for consistency in interpretation of law can lead to public confidence in judicial system. A subordinate judicial officer works mostly in a charged atmosphere. He may be psychological pressure, the contestant and lawyers breathing down his neck. Judges bashing has become a favorite pastime. Some people. There is growing tendency of belittling the reputation of judicial officer by disgruntled elements who fail to secure an order which they desire for functioning of democracy and independent judiciary to dispense with justice without fear and favor is permanent. Judiciary should not be reduced to position of flies in the hands of wanton boys. In case the High Court does not protect honest judicial officers, the survival of judicial system would itself be in danger. Vice versa, we have an occupation also. So these are the three definitions of judicial activism, judicial decorum, and judicial discipline. These are may seen as separate topics, but it is interconnected topic. And if these three topics are together in the courtroom, it will give a good judgment and safeguard our fundamental and constitutional right. This is my submission made. through my speech. If I committed any mistake, please pardon me because of a technical fault. I could not present properly and smoothly also.